Thank you, Connor, and thank you everybody for joining us for Persuasive Brief Writing 1, Structure and Organization. As you've heard, I'm your moderator today, Max Stein. This webinar is part of the Financial Poise series on persuasive brief writing. Slides 6 through 9 provide a summary of the series in this episode. Speaking of those slides, you should understand from the get-go that we will not be stepping through the things in the PowerPoint order necessarily, nor will you have to listen to us read any of these slides. This webinar, like all Financial Poise webinars, is going to be a conversation. You should keep the PowerPoint handy though, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes, and I will try to move the slides on the screen as we go. Joining me on the panel for today's conversation are Stephen Brodsky from Mazzola Lindstrom, Julie Schrager from Fagery, Drinker, Biddle, and Reith, and again, my name is Max Stein of Totus Law here in Chicago. We appreciate that you are not spending your time and money to attend this webinar to hear infomercials about us. You can, though, if you're curious, read more about us on slides 30 through 33. Thanks to our sponsors for today's episode, Mood Hardworking Cannabis, Sunburst Digital, maker of Type to Learn, the #1 typing app for education, and Max Assist, restructuring and insolvency professionals. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com/subscribe. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get you an answer. And with that, let's get the show on the road. So we are talking about structure and organization for persuasive brief writing today. And as lawyers often do, we're going to start before we even get to the topic by talking about things you think about before you start writing. And so one key practice to know about is to make sure that you know exactly what you want to ask the court to do. Stephen, can you talk a little bit about why this is so important, how lawyers can make sure they are asking for the right thing?
Sure. As everything that an attorney does, you should be thinking about what your goal is, what your intention is. And so with brief writing, there's multiple levels, knowing, first of all, if it's a motion on the pleadings or if it's a motion for summary judgment. So obviously there is a critical difference between the two. A motion on the pleadings, as we all know, is directed to the legal insufficiency of the claims for various reasons. A motion for summary judgment is wholly different, predicated on the lack of a question of fact. So number one, know what is going on with that. And then number two, the purpose of the document that you're drafting, for example, and then we'll go into this later on. Is it a initial memorandum of law supporting your motion papers, or is it the reply? The reply is very different. You are responding to the arguments in opposition. And conversely, if you're opposing the motion, know the purpose of that, which is to oppose and to state that to address the legal points, or in the case of a summary judgment motion, the facts, the factual issues, or rather that there are factual issues. So those are all the different ways in which what you're drafting will be different based on the purpose, based on the stage or the particular motion.
Thank you, Stephen. So one of the other things that is important is the process that people use for how they're going to put together their persuasive writing efforts. Julie, I've got a bit of a process question for you. Do you prepare outlines for most briefs you write, or do you just sort of start writing? And if you do outlines, how detailed are they, and how do they help you through the writing process?
Max, I am very happy to answer your question because I love outlining, but first I would love to just add on to what Stephen said about telling the court what you want it to do. I would also add, before you start writing, you need to also understand why the court should do what you want it to do. And I'm a huge advocate of both of those things go on the first page of your brief so that no one has to turn a page before knowing what you want the court to do and why it should agree with your arguments and your client. And especially, this is like, it's like a 30-second elevator speech for a brief. You should be able to articulate that to people you're speaking with. And you've got to be really precise there. So recently I was working with someone who we were working on an appeal in the Colorado Court of Appeals, and it wasn't clear at the outset whether we were asking the appellate judges to vacate what the lower court did or to reverse and remand it, or exactly what we needed. So you want to pin that down. And then what Stephen said that I really love is you have to understand the legal standard, because everything you want the court to do is going to come with a different legal standard. And you are going to frame all of your arguments in light of that legal standard, right? So if it is a motion to dismiss, it's going to be on what the complaint said, and the argument is that, you know, there are no facts. You'll take the facts and read them in the light most favorable to the plaintiff. And even doing that, the plaintiff doesn't state a cause of action. This is if it's like a 12b6 motion to dismiss. And summary judgment, obviously different rules. You've got to show no genuine dispute of material fact and that your client is entitled to judgment as a matter of law. So thinking about the legal standard and also having those reasons there. So yes, I'm a huge fan of process in like everything we do as legal writers, because when you have a process for it, it's just way less intimidating. It goes way more smoothly. You're much less likely to like trip up when you're like the day before and you're like, oh man, I forgot this really important argument. Where am I going to stick it in there? How am I going to move things around? I'm out of pages. So I like to start with like a back of the envelope outline, which is here's what I want and why I should get it. Here are like my 3 reasons. I do try to write them out as complete sentences that are my points, because that helps guide what I do. And then under that, I just do some like cutting and pasting and moving things around. Like I stick some law under there, you know, whatever the statutes, the regulations, the cases, whatever I'm planning on using. And then under that, I stick some facts. And this is like in note form at this point, not written out sentences. Because pretty much all legal argument follows that structure, right? We start with our point, then you set out the rule and you explain it, and you've gotten that from the law that you've been reading, and then you apply it to the facts of your case. So that's my method. And once you do that, the rest of the writing part's like filling in the blanks.
You know, it's
Indeed.
Max, I want to jump in because
Please.
it's good that both Julie and I are here, because my process is completely different. And I'm focused more on an intermediate to an advanced writer. You know, what I do, I don't use outlines. I basically think in my head what I want to say. And going back to the point of the first question is to just think for a second. You know, I took your question to be in the process of writing. So I think, what are we trying to accomplish here? Are we trying to accomplish focusing on the legalities, or are we trying to focus on the facts, for example, or whatever the point of the motion is? So regardless, for this, for outlining, I end up using my computer screen as like a potter's wheel. I might attack an aspect of the motion, the back end or a middle part or a part that I have trouble with or that I'm interested in. I will also have another screen open for case law, and I'll read the entire case on the other screen. Then I might cut and paste there. And I basically, that's what I do. So I might start at one point and then go to another. I don't process linearly. I go kind of horizontally, and then I go from there. So I think it depends on, you know, how you write and what stage you're at in writing and how you think. And what's successful for each person individually, I think is important.
Indeed. I think it's actually interesting because I'm somewhere in between the two of you, I think. I usually have a pretty high level outline in my head that I then try to reduce to a written form and we'll include some of the key ideas along the lines of what Julie was saying. But at the same time, I think I'm doing a little bit of the more surrealist approach that you're using, Stephen, where I'm jumping around. And actually, one of the things that I find is when I'm writing, if I get stuck, I think to myself, which of those two things am I doing more? Am I doing more of the sort of surrealist jumping around thing, or am I doing more of the structural thing? And whatever it is that I'm doing more of when I'm stuck, I try to switch to the other one to try to get myself unstuck. And then I usually get going again and have to come to a point where, wait, I need to organize this, or wait, I need to stop focusing so much on the organization and go back to getting to the point of it all. So it is really very interesting to listen to different approaches and understand how each person's approach is going to need to be tailored to them. And really what we're talking about are offering tools that we can offer to help people figure out what might work best for them.
Now, mind you, I just want to say, Max, when you look at my final product, like right before this, I oversaw the filing of a reply brief. The final product is not surrealist. It's very, it is the opposite of surrealism. And I studied surrealism. It's not, it's extremely linear. It's extremely easy peasy for the reader to read, and it flows completely logically with some poetry. That's all I wanted to say, which is it's the process in creating it. Whatever works for the person, for you, then follow that, I think.
Well, and just what I would add to that is, so I'm an in-house legal writing coach at a super big law firm, and I work principally with lawyers in their first several years of practice. And I would guess, Stephen and Max, that you guys were more linear before you became more surreal. So as a first step, you want to make sure that you've included all of the points you need to include in whatever it is that you're writing. That your law is super strong and airtight, that you've got your, cites to the right facts, and sort of poetry, I would say, and more creativity come later once you've mastered some of those basics.
Absolutely. So one of the things that I think, even in our differing approaches, we will all agree on is that a strong attention-grabbing introduction is very useful and helpful. Julie, you already talked about the importance of that first page and being clear and precise on that first page, but can you share some more tips about how you help people create winning intros?
Sure. Well, first, I'm super, and I bet Stephen agrees with me about this, I'm super super formal introductions that have all these like abbreviations and parentheticals and short forms in them, because a judge just can't even read, and you don't want to be interrupting your reader in the most important page of your brief. So I am a write the introduction first, but then revisit about 1 million times as you're going along and at the end. I need it to warm up my thinking and writing on a brief. My general rule, and this one I just made up, and I welcome your thoughts. My general rule is that an introduction section to a brief can be 10% of the length of the argument section. So 10-page argument, 1-page introduction. You guys can do the math beyond that.
Interesting. What do you think, Stephen?
I think I think you mean the preliminary statement, the introduction being the preliminary statement. I write it.
Whatever the type of brief it is, it
Right.
might have a different title.
Right. I write it last, and I write it, after I've written the draft of the brief, the whatever it's called and so forth. It should be extremely clear. It should lay out in summary the arguments, not in a rote fashion, but in a compelling fashion that builds and tells the reader what you're going to argue. It's an art. I mean, I think Julie's comment is well taken. I have been practicing 30 years, so this is second nature for me. But however you write it, it should be clear. It should lay out the sum total of your argument in a succinct fashion. And there should be a hook, a grab, if you will. And that comes from just sensitivity to what is really the nub of what you want to say. And it could be, and we'll get into this later on, and there could be a hook, such as a failing, as I just did on a reply brief. It's a contract, essentially a contract complaint, but there's a purchase order at issue for a lot of money, and the purchase order I had submitted on in the motion, and they did not refute it. So the nub of the reply was that there's no reason to proceed further. The purchase order governs the terms of the parties' agreement and actually refutes the refutes the allegations and so forth. So it's on a case by case, but there is usually a very strong thing to lead off with.
I would also add there just two little points. I sometimes find that newer lawyers feel like, well, my supervisor is going to edit this dramatically anyway, so why should I even bother to do my best job on this introduction? And like, that's a bad call, right? You should still endeavor, because like Stephen was saying, it's your crystallized best thinking, and it will show, even if it ends up getting edited, it shows that you made the effort, that you really thought through everything there. And then I know there's another session to talk about like writing style, but I don't like being, you want a nub, you want a theme, you don't want to be over the top, as my opponents are the stupidest lawyers who've ever existed on this planet. No judge wants that. I mean, no judge wants that anywhere in your brief, but I would say they particularly do not want that in the introduction.
Yeah, and I think it's interesting because I find that I generally write the introduction first and then reread it after each piece that I've done, and I would guess I end up spending about half my time editing the introduction, which isn't because the introduction needs to be edited that much. It's because, as you were saying, Julie, by doing that, I'm further crystallizing my thinking and further refining the arguments. So then I make a point, then I clarify something for myself in the introduction, and I get to carry that forward into the rest of the brief after that. I've been thinking about your 10% rule, and I think I'm a little bit over it on usually, but it probably is a good yardstick to try to keep the introduction as succinct as possible.
One thing,
Stephen,
I'm sorry, yeah, one thing I'll add, which is what I imagine junior attorneys get tripped up by, is the repetitive. And don't be repetitive, aside from the fact that you should never engage in ad hominem attacks. I mean, that goes without saying. But you shouldn't repeat. So in a sense, the preliminary statement or the introduction, and this is, I go back and forth. When I don't fully, I mean, I draft sentences, if you will, that go into the preliminary statement or the introduction, and then I'll tie it in, or I'll make an echo statement to the effect in the body. So, because I make sure that I don't want to have a repetitious tone in whatever I'm saying, but it's really, and that's the only thing. I think that junior attorneys should not be fearful of feeling like, oh, do I need to say this again, or so forth. Don't worry about it. The judges are smart and they can handle it. So just don't be repetitious. It comes across very poorly.
I also want to circle back to something you said, Julie. I think you're absolutely right that younger attorneys should be writing those intros, but by the same token, they shouldn't feel badly when their supervising attorney decides to write their own entire intro and not a word of their intro makes it into the final product.
100%. But I think, I think about this all the time, is sometimes you don't have the same amount of experience as the person you're writing for, but you are actually doing the work. And so they do want to see you do the work so they can react to your work. Sometimes their initial introduction draft might have been, not great either, but you're setting them up for success by giving them something that they can work with. We all know that editing is so much easier than writing from scratch. I mean, sign me up for that. Well, actually, that is my job, and I have signed up for that, and I adore it because I never have to start things from scratch. But so know that you're doing them a service, even if every word gets changed.
Yeah, and
absolutely.
I'll close out this issue, which, as I'll say, this is a topic that if we're talking about junior attorneys, absolutely they should be writing everything, not only for what all the reasons Julie said, but because the firm and the senior partner is their client. Okay, their job is to keep their job and to show their value. And the best way to show value among having your, aside from having your own clients, is to show that you're a good attorney. And so whoever, of course, the other partner, if the partner has feelings or whatever, is gonna write whatever they want, I suppose. But they need to see that the attorney that they are asking to do the work can do the work, and they will take notice, and they will turn back to you or the junior attorney if they believe that they have the chops to go for it. And so use your chance to prove yourself to your essentially your client.
Indeed. So we've talked now about the introduction, and most briefs are going to have a few different sections, the introduction being one of them. And I want to step into the next section of the brief, which is usually going to be your background section or your facts section. Stephen, here, do you have thoughts about whether background sections or fact sections should be presented chronologically?
Generally speaking, if it's a if you're going through an iteration of the facts, such as in a summary judgment motion, yes. I think it's easiest, whatever is clearest and easiest. So it's pretty rare not to. The thing where I can think of, let's say, if there is a very important aspect of the contract or events where you might want to get into it, but I think by and large, absolutely by a chronological fashion, yes.
Julie, feel free to talk about how to order things, but I'm also curious from you about how to strike that right balance of being neutral in your presentation of facts while perhaps also putting a gloss or a slant on things to try to help get to where you want the court to get.
Of course. So I am with Stephen in that chronological is your default unless you have a strong reason or ability to do it otherwise. That said, when you're thinking chronologically, think how various things are related to each other, as opposed to just being like on date, on date, on date. That's boring and requires people to like do some math about how that's related. So it's often more significant to say, 3 days later, like that was like right away, we did something and we were just on it. So 3 days later is more effective than, on May 2nd and on May 5th.
Yeah, actually, let me just jump in right there. I will say, I often find that the best way to relay those kinds of things is to relay the sequence of events and explain the significance of the event, and then provide the data, the fact of the date or that kind of thing. Because by doing it in that order, where you first say 3 days later they breached the contract, you've explained to the court why the date you're about to give them, January 26, 2024, is significant. And they're much more likely to remember that date as things go forward than if you put that date at the very beginning, where it just becomes background noise and they don't even know why it's there.
Right. And that ties into sort of a broader point, which is that everything you write should show the court why they should care about it. And, putting the date after makes that fact. So you asked Max about being neutral. As an advocate, you are not neutral in anything you are writing, not in any section of this brief. So you, of course, must conform to all the ethical standards, and you are not going to leave out facts that are significant that the other side is going to rely on and then make you look like you're unethical. You are going to accurately reflect the facts, so you're not going to present them in ways that are completely unfair, but you're going to use the facts in a way that helps your client. So that means really good facts get spelled out in more detail. They get placed at the start or the end of paragraphs. Worse facts get placed in the middle of paragraphs. They're described with less vividness. They're often combined with good facts. Because by the time the court finishes the factual background section, the court should be on your side without you having done any argument. that it should just be obvious. And then one thing, because I can't ever talk about fact sections without citing to one of my favorite fact sections of all times. I bet you guys know this brief. It's Chief Justice Roberts' brief in this well-known case called EPA versus Alaska, where he represented the state of Alaska that was fighting back against, it was like emission regulations for coal mines. And while most of us are not filing Supreme Court briefs most of the time, it's a great example of how sometimes you can look at facts in a way, and he came up with a theme that I could say that maybe nobody else in the world would have figured should be the theme of that brief. So everybody should take a look at that.
The only thing I would add, Max, is the tone, is to watch your tone, which is certainly we're advocates without question, but the most important stock one has as an advocate is credibility, I believe, with the court, because once you lose credibility, everything goes downhill from there. So in the fact section, first of all, as I said before, never be snarky, never engage in over the top snarky critical comments like that, except what I'm not accept. And I will add that in the fact section, I think it should be a bit more just the facts, if you will, less not commentary, because your credibility there is that you're laying out the facts and without argument, essentially. And of course, you are making argument in a neutral fashion, but it's just be careful not to keep a neutral tone in the writing. That's what I would recommend.
I agree, and I have my Mark Twain mug here. I don't know if you can see it. It says, when you catch an adjective, kill it. So no adjectives, no adverbs, no like unbelievably, the plaintiff then, did stuff like that. So I'm with you, just good verbs and good nouns and good organization.
I do want to reemphasize something you said, Julie, which is at the end of the fact section, when you've read the fact section, the outcome should be obvious. So if you've done this right, you've written a compelling introduction that is clear and concise and asks for the outcome that you want. And then you have a fact section that presents the facts in a way that demonstrates that, well, of course, that thing you just asked for at the end of your introduction is obviously the right answer based on these facts. And that if you get to the end of your fact section and you're like, well, this is a close call, you need to go back and look at the fact section again and figure out how to make it better tie to your themes, your introduction, and what you're looking for. I will also note, I often find that Stephen's exactly right about tone and how important that is. I will acknowledge that, especially in fact sections that end up being longer because they're more detailed and they need to be more detailed, I find that as you get closer and closer to the argument section, the tone begins to change a little bit. And you can have a little bit of advocacy, of clearer advocacy, slip into your fact section towards the end of your fact section than you should have at the beginning. And that's in part because, as Stephen noted, you've established your credibility and you've established that you're telling the tale correctly and accurately. And by the time you're getting to that end, it should be headed your way. And so you start to acknowledge that.
Yeah, and just to, I was thinking about what Julie said and what you're saying. I think it's important for junior attorneys out here listening or watching to actually read good writing. And so, the way that one learns is by seeing, because we're talking in the abstract here, and it's very hard, I imagine, to understand what we are saying without actually seeing it. So I would recommend to anyone out there to read the briefs of well-known good writers in your firms, letters and so forth, and take be observant, see how that person or how that brief expresses, and then compare it to other folks and so forth, and then think about so it's important. The more that you see examples, the better that you will understand what we're talking about and what works and what doesn't work, and then what will work for the particular person.
There's a great book out there. I don't know if you guys have ever read Point Made by Ross Guberman. That's a really nice example. It's a book that has examples of great writing and sorted by what were the methods that they used, that and shows you like what makes using numbers, for example, effective, or what makes using vivid language effective. So I think it's got something to offer lawyers at every level of litigation experience.
Thank you. So now we're going to slide next into the real heart of a brief, usually the argument section. And when I was in law school, we were taught the IRAC approach: issue, rule, application, conclusion, especially for memos and other sort of down the middle writing. For persuasive writing, the rule was tweaked, and I was taught a very bad acronym, CRAPA, CRPA, which was conclusion, rule, proof, and application. Julie, you had CRAC, CRAC, which is certainly a better in terms of an acronym. And in both of those instances, the important thing is instead of beginning with a dispassionate presentation of a question, you're beginning with a advocacy piece where you're expressing what the conclusion should be, and then you're going to explain why that is the right conclusion. I will note, I still find, so I talked earlier about things that I go back to when I sort of get stuck. This is still a very, very effective method for me, and something that I go back to when I'm having trouble working through an argument or dealing with writer's block. Julie, I know you're an advocate of these things too. Can you talk a little bit about how you use this approach in your writing and in your coaching?
Well, I think so. I often find that newer lawyers are more hesitant to reach conclusions because they feel like, oh man, how am I supposed to, how can I feel confident in what my point is here? And that's why I worry about starting with an issue, because you've really got to push people to start with the point. And then, sometimes, I know we're going to talk after you've stated that point, what follows in all traditional legal writing is a statement and an explanation of the rule. Okay, and the rule is coming to you from all of the research that you've done in the statutes, regulations, case law, wherever you are getting your rule. You always know that rules come from primary authority. This is for like the newest lawyers, not from secondary authority. So just to remember that. And then, and I totally defer to Stephen on this, like how much you have to explain and illustrate and prove the rule is an art, not a science, right? It really depends on how complicated it is, whether it's disputed, whether it's very clear. If it's going to be something like, oh, here's the standard for summary judgment, you don't need 5 cases to set that out. You cite to the Federal Rule of Civil Procedure. If you have one case in your district, if you're in federal district court that went the way you want this court to go, bang, you're done there. And then, and you're often going to rely not on full case descriptions, but on parentheticals, on like pithy quotes, not a lot of block quotes, because judges report hating those. And then you're going to apply this law that you've been explaining to the facts of your case. And there are going to be cases where, this varies modestly, but as a sort of default argument structure, I think it's a great place to begin.
Stephen, is this something that you find yourself using either consciously or subconsciously?
I think subconsciously. I think I would put it this way. I call it making a point, then giving the reason, whatever the point is. So, make your point and then explain it, the bases, and then conclude it. And I think, that's just the way that I think, and that's where you present in the macro fashion. And then I guess I rely more on the art throughout the way. But I think the point is maybe that junior attorneys should think about is, if they can, is to get used to thinking in your head, or whatever it is, if you write down, but like trying to be clear on what you are saying, okay? Which is why sometimes, if there are, in my day when I started out, there were people above me who dictated their briefs, which shocked me. But there's an art form that they developed, which a skill, if you will, where they thought in their head what they were going to say, and then while they were supposedly dictated, they had everything in their head already. So whatever your modality is to think first what you want to say it, and then give your reasons, and then conclude. So I guess it's an inchoate type of subconscious thing that I do.
And you've internalized it. That's the
Right.
thing. You learned it and you've so internalized it. What I also tell people all the time is, I don't know how you guys felt, but I hated geometry. It was like my least favorite math class in high school. I couldn't stand it. And I just sort of didn't understand why you had to go through this whole process before you got to the answer, right? To the point. Well, lots of legal writers, newer legal writers, they write like that. And so the point is in like the last sentence of your paragraph instead of the first sentence of your paragraph. So think geometry and then completely reverse it. You start with your point and then you prove it after.
I think it's amusing that you hated geometry, which I loved in high school, because there is a lot about legal writing that is like doing a geometry proof. You need to show your work, you need to show the steps, you need to build up to it, and then you're right, you just got to turn it upside down.
Right. It's a great editing tool, though. So, for some people, if they have a hard time with that, it's just always look at those last sentences and you'll move them up and it's super easy.
Yeah, one of my big debates when I'm editing my briefs is often whether my last sentence should be the last sentence of the paragraph or the first sentence of the next paragraph. And that's how I know it's the building is working, and it's just a question of in which order these things are going to happen. One of the other things that you touched on, Julie, was the proof part, where you're showing that this really is the rule. And I think that really is something that is art, not science. And young lawyers should be mindful of the fact that you got to, it's going to be hard to figure out how to do that, how much is necessary there. But getting that right really does demonstrate that you are developing the skills you need to be a good advocate by showing, here's the right combination of my words as to what the rule is, this court's words as to what the rule is, and all of this presented together makes a compelling case that yes, this really is the rule and I'm stating it correctly. And the court can now be comfortable that I've got this right. My senior lawyer can be comfortable that I've got this right. And now we can move on to how this applies. For me personally, I often find that I want to get to the application as quickly as possible because that's my case, not the general point. And what I have to remind myself is that I need to make sure that the court is ready to get to that application before I stop trying to prove the rule as I've articulated it.
Yeah, the thing I would like to add on that, Max, what you just, something you touched upon is there is a balance and it's an art form. So for example, if there's a case that's on point, truly on point, or there's an analysis by a court which is compelling, perhaps you go into and discuss that case in more than a parenthetical, but don't follow, in my view, and it takes time to get to this level, don't follow a rote manner of, in such and such case, da-da-da-da-da, and da-da-da-da, and so forth. And it may be that when you get to the point where it may be stringing, not saying, the second department or the Southern District has consistently ruled as follows, it has consistently dismissed case that in this fashion, and then you have the parentheticals with very compelling parentheticals as opposed to long laborious statements. So, but it's more art than logic, because if you follow more of a rote pattern, it becomes very not compelling. It's almost like as if we were to be reading a script as opposed to speaking, right? So there's a mix there. It may be that it may be like there was a discussion about why a statute should be amended. And this is an example of showing why the statute was amended to handle this exact case. It depends on the scenario, but whatever it is, there's different ways to be compelling. And it takes time to find the right balance and the mix, if you will, to keep it interesting.
I totally agree. And then the other thing not to overlook is citations are persuasive, like themselves. I mean, good cases, recent cases, good judges, good reasoning, those are super persuasive. And then just also for people, like the Blue Book gets a bad rap, but its explanation of explanatory parentheticals is very helpful and useful. And I think for most people, it should be your default, unless you're, in a court that follows different rules, but at least to get started at drafting effective parentheticals, it's a good place to start.
Absolutely. And I think that you cannot underestimate how important it is for those parentheticals to be short, concise, and dead on the point. Because if you can explain why a case helps your side in literally one line of text in a brief, you're telling the court that this is a really good case for you. You don't have to put in a whole bunch of caveats. You don't have to add other things. It's clear that this is the case that helps you, and you should make that clear even through those parentheticals.
And when Stephen said, if you're going to say the court consistently rules blah, 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 you need more than one case to support that, just as an FYI.
Yes. And when you have an old case, the courts have long held. That's one of my favorite.
I'll let you use that adjective, just that.
So next, I want to start talking about the logical flow and structure. And Julia, I'm going to ask you about this because it goes back to your geometry proof point. Getting the exact logical flow for an argument is like building a little machine, and it needs to be balanced just right to work. How do you approach figuring out what makes the most sense as you're going through the arguments and what should go where?
Well, in terms of, if we're talking about order of arguments, sometimes there's an obvious order, right? If you've got to do something that's procedural before you do something that's substantive, or you're choosing to address something in the plaintiff's complaint in the order in which the plaintiff sort of lists them. But, sometimes you're focusing on strength first before yours. I always, just to get back to that whole, like, how you're explaining rules and cases and all that, I always try to be over-inclusive first and then cut back. It's much harder later in the writing process to add more law, because then you often will be like, I need something more, but, at that point, you start off by just, being a little more in-depth in detail, and then you can always be like, oh, this is my third case on this point, I absolutely don't need it anymore.
Stephen, do you have any thoughts about how to strike the right balance and figuring out the logical flow of the argument?
I just think that, and this is something that comes over time, is to have in mind your entire brief, or as you're writing, and so where things fit. Because I was looking at, actually, this page 24 says rebut all of your arguments and distinguish all of their authority, with all in all caps. And that's another art form, because and it goes with your question, with your comment there, which is be complete but be effective. So I don't necessarily think, I don't really agree with distinguishing every case, okay? Because then you're going to undercut your credibility, and no one is going to read that. But you can do that in a thematic fashion, which is to say, plaintiff's side, cites no case in which or, plaintiff's cases dealt with real property, camels, and so forth. None of them dealt with the house that was painted blue on a Tuesday or something. In other words, you can do that without going to every single case. You can see the theme, if you will, and you can do it in a macro fashion. So you're doing the job in a effective way, I think. And so I just think with the analysis, I'm sorry, I wish I could bring it down to a more nuts and bolts level. I just think it's something that you get used to, and you just be sensitive to where you are in the argument and what the reader is thinking. Always think about how the reader where they're at and how they would be. So I think that's important.
And you remember, at the end of the day, you win because you're right on the law and the facts, not because your opponent is stupid. So distinguishing every single case just makes it seem like you're being petty, and it doesn't really get to the point about why your argument is effective.
Yeah, I agree with both of you about this particular bullet point that happens to be on slide 24, and it's pulling back the curtain on how we do things here at Financial Poise a little bit. This was in the existing deck, and I actually looked at it and thought, huh, and now I realize I really I almost put a question mark at the end of the bullet point, and now I realize I should have, because that's I'm exactly where you guys are too. And I have a few friends who are judges, and one of the things that they always tell me is how annoying it is to read briefs that have responded to absolutely everything, because the judge has already figured out what is going to be important. And I always have to remind them, well, yeah, but you're doing that at the end of the process. That brief was written in the middle of the process, and you didn't tell anybody that you'd already determined that the third argument was a dumb argument and you weren't going to worry about it.
True, but that goes with another point, which is, which goes over structure, which I think we're going to talk about later on, which is really why should the judge rule your way, which is what is the true, I was going to say, don't lead with your chin, lead with your strongest point. So you may not be attacking every single point, because because let's say the plaintiff is engaging in a lot, or the other side, whatever, is all of their thing, it's a smoke screen, right? And you just cut through the heart. Because what your friends have told you, which is, and I know this because I know the same thing, they have already decided how they want the case to go, or not how they believe it should be decided. And then they tell their clerks to write the opinion to make it go that way. Essentially, sorry to pull back the curtain, folks, but that's the way it's going. So when you're presenting the argument, understand that. What is the few reasons why you're correct or your client is correct? And then everything else supports that. So it's really like knowing the main points that you want to, the thrust, if you will.
Yeah, I have a friend who clerked for an appellate court. I won't identify the court, who wrote an opinion, and the judge said, this is a great opinion. It's very well written. You just need to change a few things here, here, and here. And it was to reverse it was to, instead of reversing, to affirm the lower court's decision without changing the logic, without changing anything else, just those few things, and everything was good.
Exactly.
But that might also be one of these examples where the judge needed to read it to actually decide, that it was like close, but he felt like when he or she, when he looked at the law and the facts, that went the other way.
True. So one of the things that is very noticeable in briefs and can be very important in briefs is the argument headings. And Stephen, I want to ask you whether you have any sort of rules of thumb about length, tone, style for argument headings.
I do. So again, I make sure, notwithstanding my surrealistic / chaotic drafting style, the final product has signposts all over it. It has almost blinking lights, if you will, and what we're going to talk about. So the headings are very important because they chunk up the analysis. They tell that they are signposts for the reader. And I write short headings. Okay, I don't like long headings. The plaintiff, da 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 da. You encapsulate what is the thrust of this particular part of the argument when you bring it down to the nub, and you can even use some make a zinger, if you will, and not a caustic zinger, meaning like a flair, some flair, and make that your heading. That make it grabbing, but credibility, keep your credibility, and do that. And I think, because also the reader, think about the reader. Are they literally going to read, a long heading? No, they're going to gloss over it. As that's the way we all think. If they see a 4-word heading or a 5-word heading, they're going to say, this is about, the camel that spit in the guy's eyes, going with the camel theme, or something like that, as opposed to once upon a time and this, and so forth. It gets lost. So think about how the reader would react to it.
All right, all you people out there, I don't think anybody can really, it's really hard to write a 4 or 5 word effective heading. I would say go for it, but I'm cool with getting onto the second line. But I don't think it should get longer than that. And if you see that you have a because in there and it's getting longer, that's just a sign to you that you need subheadings that will set out your reasons. And subheadings are really nice too.
I'm actually of the view that 2 lines is the exact right amount because 1 line actually can get missed, and you want this as such a big, bright, blinking signpost. And your other point is exactly right, Julie. If it's getting longer than, and sometimes the length of the names of the parties makes it so that it has to get longer. But whenever I pass the 3rd line, it's clear that it needs to be trimmed down, and most likely, probably, there need to be subheadings that are going to come much sooner than they otherwise might have.
Yeah, let me amend what I was saying. When I was thinking headings, I was thinking, I guess, what you would call them subheadings. So if you're talking about a point, I guess it depends on what it is. But what I don't really favor is kind of rote headings of like the plaintiff cause of the 6th cause of action fails to state a claim. The 7th cause of action fails to state a claim. The 8th cause of action, I think, say it in a different way, which captures what you want to say, you know, and then the subheading. So, I mean, I think my only point, however long, I mean, I said 4 aspirationally and in a way to make a point as opposed to be told literally, which is just think about it goes for the same theme of like don't block indent, don't keep long block indents of you know a text because no one reads that, you know. Yeah.
I would
One-
also
one thing-
just add, I think you need a heading every 2 to 3 pages in an argument section. You can't go any longer than that. And then I also suggest to people, it's a really nice exercise when you're like done or you think you're done with a brief to pull out those headings into a table of contents, even if you don't need one for what you're filing, just take a look at it and read through, you know, all those signposts and make sure they state a clear, logical, cogent, parallel statement of your argument.
Yep. And along those same lines, and building on what Stephen was saying earlier about flair, one of the things that I often find is I go back towards the end of the drafting process and I compare my headings and my first sentences. And sometimes I reverse them because sometimes I got it better the second time or I got it better the first time, and they're both serving the same purpose. They shouldn't say the same things. And sometimes I figure out that, oh, this one's better for that purpose and this one would be better in the paragraph, and flip them around. And that's something that I would suggest everybody should do because it can really actually, it's a very small thing that can have a significant rhetorical impact on the strength of your brief.
Max, that's a phenomenal point, and that goes with the entire brief and the whole structure, which is be cognizant of how it flows and without being repetitive and so forth. And so it may be that you might even start with with an issue, with one paragraph with an issue, because you have a lot of paragraphs before that going a certain way, building up to an issue that needs to be resolved. So you say it, or it may be something else, and then you want to make a point by a series of paragraphs which are making points and building up to something. So whatever is going on, just think about what happened before, what you did before, how it went, what's going on now. And likewise, what you were talking about is even in the headings, how they interplay with each other.
I love that exercise too, Max. I also, as an editing tool, I have people just read through the first sentences of every paragraph in a brief and make sure they set out your argument.
So one thing, we're talking about how to write a good brief. Sometimes you have to respond to a less than good brief. And one thing that I've found throughout my career is that responding to a bad brief is actually much, much harder than responding to a good brief. Julie, do you have any tips for how to best handle this conundrum?
I do. So I was an assistant U.S. attorney in the civil division in Boston, and we were sued. The United States and its agencies and employees are frequently sued by pro se plaintiffs for topics like, I believe you The State Department has placed aliens in my head and they are, taking over my very existence. So you spent a lot of time trying to sort of craft arguments on behalf of the other side that were clear enough so that you could take them down. And you needed to be respectful always, because you're always being respectful of the other side. So I would say, and Stephen probably knows better than I do, it's a fine line, right? Because you do have to sort of build them up and clarify them in order to explain why the court should dismiss the complaint or throw it out in some other procedural fashion.
Yeah, Stephen, what's your thoughts on this? And have you had the same experience that at least I think I have with how hard it is, even if your opponent is grounded in the same reality that you're grounded in, they just haven't prepared a very good articulation of their positions?
I think because you need to, not you, like everyone needs to think about why it is bad. Okay, why is it bad? Is it bad because they didn't support, they're making statements that are unsupported? Is it bad because they missed a fact? Is it bad because they are going against the law in the circuit? There's a reason why it's bad. There's a reason why it's weak. Think about why it's weak, and then that is the thing to focus on. And I agree with what Julie said, to be respectful always. And I think Max, why you're saying it's difficult is because you have to crystallize to understand why is it weak, what is being missed, or what is being misdone, if you will, and then you have to address that and so forth. So, but for me, I think it depends. It might make it easier because for me, because you see what there's a reason why, and I think it's always understand the reason why and then say it clearly and straightforwardly.
I mean, I think part of the reason it can be so hard is you effectively end up having to write both briefs. You have to figure out what they should have written but didn't quite get to, and then, but once you've done that, then it's just the same exercise all over again. You get to do your part and you present your case in the best way possible.
And that's making the judge's job easy, which is what you always want to do.
Yes.
Too. So the judge will be very grateful to you if you handle it that way.
Yeah, I want to address them because we're at 3 minutes to close. That we haven't discussed is order.
Yep, I was just going there. So go ahead.
Oh,
Stephen.
sorry.
That's quite all right. So one of the things we want to talk about before we close up here is the order of the arguments. And should you follow the order that your opponent is doing something in, or should you use what you think is your best argument ordering, regardless of what your opponent has done? Stephen, why don't you jump in?
I say lead with your best. And so therefore, let's say there are 5 causes of action, and you don't have to go cause 1 through 5. You can usually it could be that this is really just a breach of contract action with everything is window dressing or reiterations of that. Whatever it is, lead with your strongest and lead with the either the weakest or the less important things towards the back.
And I would just echo, you don't defer to the other side's structure of how to order arguments, even when you're writing like an opposition or a reply. The points go within your framework, framed around your strongest, how you want the court to think about them.
Yeah, absolutely. I was actually just involved in a 7th Circuit appeal where our opponent there were 2 arguments, and our opponent, the appellant, did the arguments in one order, and we did them in the reverse order. And we did them in the reverse order because that was the best way and the most logical for our purposes. Notably, it also meant that the argument that they emphasized so much, which they hadn't emphasized before the district court and had only spent a little bit of time on, we could, by the time when we got to that argument, we could really make it clear that this is all new. And it I think, helped our advocacy in that way, in explaining to the appellate court why it was that some of the things that they were hearing now weren't addressed by the district court previously. And that I think was a useful tool, rhetorical tool for us. So we are coming close to the end of our time. And so I just want to give you each an opportunity we'll start with you, Stephen, and then go to you, Julie. Give us one or two top tips that you found yourself giving to other people about legal writing.
Thank you. I would say understand how the reader approaches it. What the job, make it easy for the reader, and always be mindful of how your writing would come across to a reader. Okay, so if it's a case where there's a lot of different cases and decisions, summarize in certain fashions. Always, whatever it is, whether it's the structure, whether it's citations, think about how it comes across to the reader. And I think if you're mindful of that, your writing overall will be more clear and more persuasive.
And I said I'd let you go next, Julie, but I was just going to jump in and say mine right here because it ties into Stephen's, which is, don't forget that while you are doing this briefing over a series of weeks, so one side moves, the next side spends 4 weeks preparing a response, and then another 2 weeks later there's a reply. The reader, likely a judge and a judge's clerk, are going to read them all at once. And you should remember that when you're writing your response, and you should remember that when you're writing your reply, that all three of these briefs are likely going to be read at more or less the same time, even though they're being prepared so much apart. Sorry, Julie, go ahead.
That's all right. I would echo what both of you said. And I think it's Nathaniel Hawthorne who said that easy reading is damned hard writing. So don't underestimate how challenging this process is. And it really requires like a lifetime of learning and practice. So if you're feeling insecure about it, that means like lean into the practice. Don't avoid it.
Indeed. It's that old saw that I think gets attributed to Twain or Shakespeare, that sorry for the long letter, I just didn't have enough time to write a shorter one.
That one's Twain.
All right. So thank you both. This concludes our webinar today. Thank you, everybody, for joining us for another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks, everyone.
Thank you.
Bye.